Hello everyone. Today we are going to talk about a new topic under environmental studies and environment law. Today's topic is environment and public nuisance. The list of topics to be covered here are environment, public nuisance, environmental nuisance, judicial interpretation of public nuisance for environment protection, case studies and conclusion. First of all, let's start with what is environment. The environment is the natural surroundings which help life to grow, nourish and destroy on this planet called Earth. Natural environment plays a great role in the existence of life on Earth and it helps human beings and animals and other living things to grow and develop naturally. As we all know, environment is the surroundings where we live and where the life it helps us to grow. This is a surroundings where all the living organisms interact with each other. But due to some bad and selfish activities of human beings, our environment is getting affected. It is the most important topic that everyone must know how to protect our environment to keep it safe forever as well as ensure the nature's balance on this planet to continue the existence of life. Now comes public nuisance. Public nuisance has been defined in section 268 of Indian Penal Code 1860 as a person is guilty of a public nuisance who does any act or is guilty of illegal omission which causes any common injury, danger or annoyance to the public or to the people in general who dwell or occupy property in the vicinity of which must necessarily cause injury, obstruction, danger, or annoyance to persons who may have occasion to use any public right. The section further explains that a common nuisance is not excused on the ground that it causes some convenience or advantage. The public nuisance covers all types of pollutions, that is pollution of land, pollution of water, pollution of air, noise pollution, etc. Section 290 of Indian Penal Code provides punishment for public nuisance which includes pollution cases also, in cases not otherwise provided for. These offences are punishable with fine which may extend to 200 rupees. So, a public nuisance is an unreasonable interference with a right common to the general public, otherwise an act or omission which materially affects the reasonable comfort, conveyance, health, safety and quality of life of a class of persons. The activities include carrying of trade, causing offensive smells, intolerable noises, dust vibrations, collection of filth that affects the health or habitability in a locality. Now comes environmental nuisance. An environmental nuisance is something that has an adverse effect on the amenity of an area, that it is caused by noise, smoke, dust, fumes, or odor and unreasonably interferes with or is likely to unreasonably interfere with the enjoyment of the area by persons who occupy a place within the area or are otherwise lawfully in the area, or it is an unsightly or offensive condition caused by contamination or waste. It is an offence to cause an environmental nuisance under Section 83 Clause 5 of the Waste Management and Pollution Control Act. The Waste Management and Pollution Control Act does not apply to mining sites, petroleum operations and pipeline operations, but similarly Offences of causing an environmental nuisance exist under different legislation. We move forward to judicial interpretations, I would like to explain further about environmental nuisance. Basically, environmental nuisance is any activity created or caused by any person who is damaging the environment, whether it is he is damaging the air, water, land, or noise. All these will be considered as pollution. So, if a person is doing any such activity which is causing damage to the environment or creating any annoyance to the other person or the public at large, that will be considered as environmental nuisance. Now, judicial interpretation for public nuisance for environment protection. The Indian judiciary started showing concern about the environmental problems much before the Rio Treaty and long before it started reaching out to international treaties to provide a jurisprudential basis for its decisions. One such innovative interpretation of the ethics code is extending criminal sanctions to the environmental problems. The judicial craftsmanship has contributed in developing a new panorama of remedy for public nuisance as provided in Criminal Procedure Code 1973 for the environment protection. Here, we will consider few case studies based on the judicial interpretation for the protection of environment by public nuisance. First case is about Free Legal Aid Cell versus Government of NCT of Delhi. In this case, the petition was filed on behalf of an association of public activists in public interest. The main grievance in this petition was that, as a result of display of fireworks and use thereof during festivals and marriages, physical and mental health hazard is suffered by adults as well as children. It was also submitted that because of indiscriminate use of loudspeakers, noise pollution has become a routine affair affecting mental as well as physical health of citizens, and it causes a nuisance. In this particular case, the public activist challenged before the court that all the loudspeaker and the use of fireworks during festivals and marriages causes physical and mental health to the persons who are involved in it, and where the particular fireworks and loudspeakers has been used. So it has been causing physical and mental health to all the persons, specifically the older people and the small children. So it was declared by the court that the use of fireworks during festivals and marriages and use of loudspeakers causes noise pollution, and it also causes a nuisance to public at large. The Delhi High Court rightly observed that the effect of noise on the health is a matter which has yet not received the full attention of our judiciary which it deserves. Pollution being wrongful contamination of the environment which causes material injury to the right of an individual, noise can well be regarded as a pollutant because it contaminates the environment, causes nuisance and affects health of a person if it exceeds a reasonable limit. Another case where Calcutta High Court in 1905 dealt is J.C. Goldstein versus Dunya. It is an important case of public nuisance. In this case, the Calcutta High Court in 1905 dealt with the problem where plaintiff complained that defendant neighboring factory is discharging the refuse liquid of its manufacturing into a municipal drain that passes along the plaintiff's garden. He alleged that the liquid is foul smelling and noxious, to the health of the neighborhood and especially himself. And secondly, that it has damaged him in health, comfort, market value of his garden property. The defendant, admitting a foul smelling of his liquid waste, but denied that it was noxious or that it has injuriously affected the plaintiff's property. He said that his factory has been licensed by the government and has been conducting the manufacturing in a lawful manner. Consequently, the subordinate judge decreed the suit, granted a perpetual injunction, and awarded the plaintiff 1,000 rupees as damage. So, if I conclude here, a public nuisance is an unreasonable interference with a right common to the general public, otherwise, an act or omission which materially affects the reasonable comfort, convenience, health, safety, and quality of life of a class of persons. The activities include carrying of trades, causing offensive smells, intolerable noises, dust, vibrations, collection of filth that affects the health or habitability in a locality.